Svetlana gonna share with us experience about the due diligence. So Svetlana, you're more than welcome. Like 20 minutes for speech and 10 minutes for questions. Thanks a lot.
Okay, thank you, Mike. Hello, everyone. First of all, a few words about me. Together with my colleagues and at Polyak & Co, we provide legal support to startups, IT business, including game dev, and venture capitalists. We cover the key areas of law that startup needs: intellectual property, contracts, venture capital investments, of course. We've been on both sides of venture capital investment deals, and I can share a few tips about due diligence. I heard that you already said a few words about it. In my experience, due diligence proves to be one of the most disturbing stages of fundraising for a startup. Founders want to manage their project and not answer the questions of the investors team. I will be talking about the legal side of due diligence, but of course, usually there is also financial and technical due diligence. Next slide, please. First of all, what is due diligence and why do investors do it? Why should you waste your time and efforts on it? Second, the next slide, please. So the whole concept of due diligence springs from caveat emptor principle, or let the buyer beware. According to this common law principle, the buyer shall examine what he or she buys, and if a buyer fails to do so, then the seller is not responsible for the defects. This examination is what we call due diligence. Another thing to keep in mind, the seller shall not conceal information. The responsibility of the investor is to ask, and your responsibility is to answer. If you do not give a full and accurate answer, then you're liable for anything you conceal. So the main purposes, I think two main purposes of due diligence are to find out any deal breakers that could preclude the investor from giving money to a project, and to draft the representations and warranties. At later stages, results of due diligence can be used to reduce the valuation of your startup, but it's not the case for the early stages, and I think we're mostly discussing early stages now. I mentioned representations and warranties. What is it? These are essentially promises that you give about your project. And I have a few examples here. Next slide, please. Here are two examples. The first paragraph essentially says that a company owns intellectual property that it needs, and the second provision says that the company is not a party to any dispute. These two paragraphs are from round A investment deal that I came across. So you can see what I'm talking about. Next slide, please. Warranties usually apply with exceptions that are described in a disclosure letter. I'm sure you've heard about disclosure letters. Here's an example. If during due diligence, you tell your investor that there is a dispute between your company and one of your suppliers, and later you include the details of this dispute in the disclosure letter, then a no litigation warranty won't apply to this dispute. If you don't tell your investor about some issues in the course of due diligence, and later you mention them in a disclosure letter, then the investor simply will refuse to sign it. So don't do that. Don't conceal the facts till you have to sign. Next slide, please. So why would you care about these warranties? Isn't it just another business risk? And to answer this question, we need to find out who is responsible if some warranty is not true. And usually responsible are the target company itself and the founders. Sometimes other shareholders as well, but we won't look into this right now. If there are several founders, usually the investor may sue any of them for the full amount of damages caused by a warranty being inaccurate. And the founder who got sued will then claim contribution from the others for their share of damages paid, so that the liability is distributed equally. That's what is called joint and several liability, and it's pretty much a standard. And if you refuse, somehow that's a red flag. Can you limit your liability? To some extent. And again, there are some common practices. And if you seek to limit your liability more than it is usually done, then it's also a red flag for your investor. Usually, there is no limit at all on representations and warranties regarding the title of the stock that the investor buys. Regarding anything affecting validity of the investment agreement, like corporate approvals or authority of the company to conclude the agreement, and taxes, because you don't mess with the IRS. So these three things shall be in perfect order because you are personally responsible for them. As for the other representations and warranties, the liability cap is usually equal to the amount of the amount invested. The reasoning is simple. If you are not honest with your investors and something goes wrong, at least your investors shall be able to get their money back. Of course, it doesn't work automatically, like you are not being honest and the investors get all their money back. Of course, no, they have to prove a bunch of things like causation, the amount of damages they suffered, etc., etc. And now we are getting to due diligence. Next slide, please. Usually, due diligence is performed at equity financing, although some investors may do basic due diligence before buying a safe that you discussed, I heard, or a convertible promissory note, convertible loan. The bigger the valuation and the amount of financing, the more scrupulous will be due diligence. Of course, nobody expects that an early stage startup will have documentation like Apple. The investors are more interested in financials. They don't want you to waste your money on expensive lawyers. So if you are at an early stage, they just will ask for the basics. What counts is, are there any deal breakers? Do you keep in order that little documentation that you already have? What does the process look like? Usually you sign the term sheet. It is usually non-binding, but even if it is not binding, then it will have a binding provision on confidentiality. If you don't have a term sheet, because you don't need a term sheet when you sign a safe or convertible loan, then it is reasonable to ask an investor for an NDA. If you don't have a template, NDA template, you can use something like onenda.org. I forgot to include it in the presentation, but I will write it in the chat. Yeah, here it is. So you have an NDA. Then the investor sends you a request for information and a bunch of questions. We'll consider them later. You respond and upload all documentation to virtual data room. There's a lot of solutions for virtual data rooms, like Ideals for data, Box, Secure Docs, Merrill, Deal Room. Usually they cost money. So at an early stage, a Google Drive folder is a good solution. But be careful and don't use anyone with the link and view option. And also remember that you have to keep your investors separate. And here's the first tip. To quickly upload the files and answer the request, you need to keep electronic copies of all your documentation. That's everything you sign, including corporate paperwork, agreements, everything you file with the state or federal authorities, every invoice you pay or issue. Sign electronically everything that you can. Use services like DocuSign, HelloSign, etc. There's also a bunch of them. Organize your files so that you can easily find what you are looking for and not search through your emails, messages, and phone. Next slide, please. Here you can see an overview of the topics that will be covered in due diligence request. We'll look closer at each one of them. Next slide, please. And the first one is corporate documentation, of course. So this means everything related to incorporation, including articles of incorporation, bylaws, or if you are an LLC, you will have an operating agreement, etc. And here's the typical problem. For example, one of the founders incorporated a Delaware C Corp, signed only what is submitted to the Department of State, and the other founders are shown in the cap table, but you don't have any paperwork. Anything that proves that they received the shares they are supposed to own. What to do? First of all, they could have incorporated together from the start, or if only one of them incorporated the company, he could either sell some stock to his co-founders to bring the situation in compliance with the cap table, or he could issue additional stock for them. So the bottom line here, your paperwork shall correspond to your cap table. What else an investor will ask for? Well, all resolutions taken by the stockholders of the board of directors. And yes, even if they were signed a few years ago, there's no statute of limitations here. So you have to keep all resolutions from the start, from the incorporation of the company. It's a standard question you'll be asked at every investment round. So sign everything when you're supposed to sign and keep the files organized. Sometimes I see clients who ask to prepare only the documents that are filed with the Department of State because they're trying to keep the expenses low, but it's not a good thing because in the United States, a company isn't usually required to disclose much. In jurisdictions like UK, if you issue shares, you have to file the documentation with the government. It's not like that in the US. But it doesn't mean that you don't have to work on these papers. So yes, corporate actions have to be documented. Next thing that the investor will ask for is fundraising history. It's a pain, honestly, because sometimes startups just dump everything related to the fundraising history in one folder, like some loan agreements from some individuals, without explaining who they are, some strange looking term sheets, without even explaining were there any deal, was there any deal that followed these term sheets or not. I find it rude, honestly. A decent way to answer would be to give a timeline, which can be in a separate Google Doc or maybe Google Sheet. For example, you can say we received some money before incorporation, we spent it, then we incorporated, and then that's why we issued shares at nominal value, even though one of our shareholders is an investor. Then we received some convertible loan. You can see documents here and here. It's a simple thing for you, but it will save a lot of time for the investors team. So be decent, just do it. And of course, it's not a full list of what is usually requested. But if you're an early stage startup, essentially that's what you will have. And most probably your answer not applicable to the remaining questions. Next slide, please. Yeah, let's move to team and employment. So yes, team is one of the key things that are most important to an investor, another thing being your product, of course. The investor wants to know if you have a qualified team and if the members of your team are motivated and if there are any associated risks. So start with making an organization chart, even if you're not asked to. Depending on your situation, you may partially reject the names of everyone who's not a founder, like keep the personal name and the first letter of the surname. You can't reject too much because it would impede with due diligence. For example, you'll be probably asked to provide contracts with each member of a team, including founders. And yes, sometimes I hear that the founder's consideration for the job he or she is doing is the shares he gets. So why would they have a contract? I don't agree. But even if a founder is not paid for now, he must have a contract. The contract must ensure that the work product is assigned to the company. It also must have a confidentiality obligation. And yeah, it's better be motivating. What if you want to correct the situation and sign the contract right now, but there's a lot has been developed already? It's a common situation, actually, especially for the founders, because they start working on something long before it actually becomes a project. You can assign the rights to the company. To do that, the key thing is to identify what you're assigning. You can also sign something that is usually called confidentiality information and invention assignment agreement. If you ask your lawyer to prepare one, they will understand what you are referring to. You may have noted that I said team members and not employees because an early stage startup will usually have independent contractors. These are cheaper because you don't have to comply with the employment law. But if you have employees, then you have also to show all the documentation proving that you comply with employment laws. Next slide, please. Intellectual property. Yeah, thank you. So let's start with the first important thing, a list of intellectual property you own. Many are surprised when asked to do it, but yeah, it's a useful thing. Just make a list of everything you own, who created it and when, software, art, trade secrets, domain names. I included them, even though they are not exactly intellectual property, websites, brands. If you have such a list, it will be easier for you to identify what is assigned to the company and where you have problems. Ideally, you must be able to demonstrate a chain of contracts between your company and the actual author, and the author is always an individual. If you're hiring a creative agency or an independent software development company, then probably their documentation is a mess and it's your risk. I don't say don't work with them, but if you do, just pay attention to the terms of the contract. And another thing that will be asked of you is a list of third-party intellectual property that you use, and this includes free open source software. Yeah, sometimes I joke. Sometimes I say that 5 years ago, dealers learned what is free open source software, and they are asking for it now because they want to impress their clients. So to comply with this, you need to ensure that your team understands what they can work with, and for example, what open source free software they can use, what images they can use in their work product, and where they have to consult with you. And second, keep a list. Let's move to the next slide. So finance and borrowings and taxes, well, this is the part which is only formally covered by lawyers, because in detail it is covered by the financial due diligence we are now doing. So here the lawyers only will ask for a few things. So they will ask to show all bank accounts and fintech accounts that the company has, any borrowings, including the loans from the founders, any tax benefits that you use, because it's where the problems start, and all tax returns, confirmation that you paid your taxes, and any communications with the tax authorities if you have them. Let's move to the next slide. And we are near the end, actually. So sales and material agreements. First, revenue generating contracts. If you are B2B, you may also include any non-binding documents like term sheets, letters of intent, memorandums of understanding. If you are B2C, then you need to show the onboarding process for your customers. What terms and conditions do they agree to before they proceed to payment? And if your business model is not very straightforward, it's better to make a chart showing the financial flows and a brief description of how you work. And the next part is material parts. This is you spend on like infrastructure or something that you spend a lot of money to, like office rent. And the next slide, please. Regulation and licensing. Well, this is very industry specific because it will be a huge part if you are, for example, in medtech or food tech sometimes, depending on what you do. But usually it's usually you just answer no if you, for example, simple web service. But this section may also include questions regarding processing of personally identifiable information or personal data, as it is referred in the EU. So general advice here, avoid aggressive data processing practices, because you can do that when you're small, but when you grow, it draws attention to you, negative attention. So be careful if your business model depends on processing of sensitive information, like information about health, political beliefs, or information concerning minors, and be aware of European regulation if Europe is an important market to you. I don't say it's impossible, but it just requires time and money, and sometimes a few adjustments to how you interact with your end users. And the last part is what I call miscellaneous. Next slide, please. Thank you. So if you're early stage, you'll probably answer no or not applicable to majority of the questions here. Like, do you have any dispute, any threatened or ongoing litigation? Do you have any insurance policies that you maintain? Are there any encumbrances of your assets? Are there any guarantees or security arrangements? Most probably no. It's better be no. So basically, that's what happens at due diligence. I hope I gave you a glimpse. So if you have any questions, feel free to ask. We have 7 minutes, I think.
Yeah, it's true. Thank you very much, Svetlana. We have exactly 7 minutes, and we're happy to answer your questions. Dima?
Yeah. Hi, Svetlana. Thank you very much for your presentation. Yeah, sometimes when I see a lot of how to say things to get done, I think it's not that good to make startup, but I believe it's doable. So my question is related actually on an early stage. How is your experience showing, like how long is due diligence usually? Because most of what you said is just in the beginning, like yeah, I just want to understand, is it like matter of weeks or months or like days? Usually.
Well, it heavily depends on circumstances, depending on how old is your project and how big is your team. But if you're truly early stage and you are raising your first round of financing, it mostly will be safe. I think it could probably be safe. And even if it's equity financing, you can honestly say to your investor that you don't have a lot. And one of the things that you will spend your money to is bringing your documentation in order. And it would be reasonable. So I think at an early stage, I think your due diligence will be limited to 1 or 2 weeks at most. So that's it.
Yeah, and how can I do it like simpler for investors to make? Like if I prepare, for example, say let's say Notion with all these checkpoints that you set with links to external documents, like to make my own kind of data room, like will it be easier for them than to make it like in 100 multiple resources, or like or it doesn't matter, they will request their own set of documents and their own format or whatever?
Well, it really depends on investor, but if you ask me, what you described is the dream. Honestly.
I'm just my question probably was what is the dream representation of your documents for due diligence?
Yeah. So ideal would be, yes, like you said, a Notion, structured, very clear, saying that you will find this here, this you will find here. That's what happened to our project in the past. That's who work on this project, and you can see the contracts here. That's what that would be a dream for me.
Okay, and another question regarding NDA. Like, thanks a lot for your resource. I didn't know this, like one NDA. We are in a discussion with a big kind of corporate investment, and they say they kind of not related to the company business in terms of IP, but still we kind of afraid to tell all our details, because company is basically, I'm not saying competitor, but it's very in this field where they can take our IP, right? So and we are in a physical space, in a hardware space. Is it okay, like is it normal practice to use like this standard NDA, or we should ask for some specific from our lawyers, or like what's your feedback on this?
This one NDA is good, but it also, you have to fill it in. You have to describe what information you are disclosing, and to whom you are disclosing, and the purpose of this disclosure. You have to be very specific. And this is one thing. And another thing, you have to limit how you disclose information. So you have to limit, maybe a good option would be to use not a Google Drive folder, because you can still download, and you can't prohibit downloading sometimes, or screenshot. You can't prohibit screenshots in Google Drive, definitely. And some data rooms, virtual data rooms, they have this option. So while you use a data room, you can do any screenshot, you can download files. It depends on what limitations you impose. So it may be a good thing to do. Another thing, if you have something, you mentioned hardware, I think. You can say that if they want to carry out technical due diligence, they have to come on site to you. Well, it really is, your question really depends on circumstances, but I think that's a start.
Okay, and in the case of one NDA, if I want to add my details, that's what they say, adopt one NDA. Yeah, you can adapt to your situation, like, but the core is common. Yeah. Okay. Yeah.
Yes, it's honestly, it's incorporates the best practices. If I would write an NDA, I would do something very, very similar. It's very reasonable.
Okay, thanks a lot. Yeah, thanks.
Dima, thanks for your question. Maybe someone else want to ask questions about due deal? Okay, if you don't have a question, thank you very much, Svetlana. I really appreciate you find the time to join us for today.